Yeah, tonight we're going to talk about employment law, and next Friday we'll also do for employment law. So it's scheduled for employment and labor. I don't know if I'll get to labor, but if we don't get to it today, we'll get to it next week, next Friday, that is. We start with the common law rule, which is known as employment at will, so we'll go into that. And then we'll talk a little bit about contracts of employment and wrongful discharge, which will kind of fit in with the common law rule. And then we'll talk about something a little bit along a different line, respondeat superior liability, which is liability that an employer has for his employees. And after that, we'll get into anti-discrimination statutes and other employment statutes, and then we'll do labor law. And common law rule, like I said, is called employment at will. And what that is that just as when you're renting an apartment, you can terminate the apartment at any time except you have a contract. Well, if you had a contract, you wouldn't be able to terminate it. It would be leasing at will. Leasing at will means that you could leave the leasehold, you could leave that apartment anytime you want it, and that the whoever owned the leasehold would be able to terminate the lease also at any time. Of course, there are some laws nowadays that restrict leases like that, but nothing really comparable in terms of employment law. So if you're working as an employee at will employee, you can quit anytime you want. I don't advise that you do that. I advise that you give the employer notice that you're quitting, give them 2 or 3 weeks notice, but you could just walk out on him. But if you do that, and future employers who might want to employ you, future places where you might want to become employed, if they call him up, he's going to tell them perhaps that, yes, he kind of walked out on me, he didn't give me any notice or anything. So you don't want to do that. But you could do that. And there might be a circumstance on which I would say you should do that, which is if there's something awful going on where it's threatening to your welfare to be there, it's going to maybe kill you to be there, or it's just not safe. If you're afraid of getting the virus at the place because there's a lot of unsafe practices going on there, you can walk out, and you would have certain rights, in that regard, because you walked out on account of that. But you're talking about a lawsuit there. I don't know if you want to go through that. But anyway, unless provided by a contract or a statute, employees are subject to arbitrary firings. That is, they can be fired for any reason at any time, even a bad reason. Literally the boss could look at you and say, I don't like you. I don't like the fact that you got a bald spot. I don't like the way that you walk around. I don't like the clothes you wear. I don't like you at all. I don't like the fact that you've been talking to the people in here, and you're making friends with my customers. He can do it for any reason. Now, these may strike you as a bad reason for firing somebody. He doesn't have to have a reason like, well, you've not been doing your job. He might want to fabricate those to make himself look good, would be all, maybe. But he has a right to fire you for any reason under employment at will. And you have a right to leave for any reason. You don't need to have a good reason. Okay, so I don't recommend employers do that either, because, how's that affect the morale of other employees to know that you're being fired just because the boss is kind of pissed at you for some reason. So remember, the constitutional protections do not apply to private sector employers. So the Constitution limits public employers. If you're working for a public if you're working in public employment, you're working for the government, they have to have reasons to be firing you. So they will need to come up with those reasons, and you can challenge those as being pretexts. And we'll talk about pretexts when we get to discrimination law. Anyway, employment at will is that way. So what can you do if you are indeed in employment at will? Well, you don't have a contract, so you can't assert contract rights, and you might claim that they had violated some public policy or perhaps some sort of tort. So let's talk about those kinds of things. First off, let's talk about contract. Contracts, most people do not work under a contract. A lot of people think that there's a contract. The guy hired you, he told you that you would be there for a year or 6 months or a month or whatever. Is that a contract? No, it's not a contract. Generally speaking, if you don't have it in writing and both of you sign, you don't have a contract. You know, so oral, yes. When we studied contract, we learned that you could have oral contracts, but it seems that as far as going in front of a judge is concerned for an employment, the general rule at common law was and still remains, in Indiana it remains this way, that you are a common law employee, meaning you are in employment at will and can be fired for any reason or for no reason or for a bad reason. Now, so if you were a professional, let's say you were a lawyer, you would probably have them sign a contract. If you were a dentist, you'd have your customers sign a contract. If your customer is a business who wants to, you know, provide dental services to all its employees, yeah, you have a contract for that. If you're an auditor, if you're an accounting firm that does audits for corporations, you're going to have a contract. You're going to be working under contract with them. Your employees will not be their employees, they'll be your employees. And so you will have control over your employees, but you will have certain duties to them to fulfill your contract. And so, you know, professionals have contracts. And they have contracts because they have the power to negotiate the contract. Ordinary workers, people who are working in, you know, typical jobs, somebody working as a cashier at McDonald's or waiting tables at a restaurant or working unloading trucks at some warehouse. You know, ordinary workers like that don't have contracts unless they have unions. So yes, at that warehouse, if you were part of a union that represented the warehouse workers where you work, you would have a contract. It would be the collective bargaining agreement that was made between the company and the union, and you know, they would have there'd probably be grievance agreements that they could only fire you. They would have to for good reasons, and so there would have to be a hearing, and you'd have a right to be represented by the union, and the union would send in representation, and these unions oftentimes hire lawyers. So in case it goes to court, there might be a lawyer representing you. On the other hand, at initial hearings within the company, it might be just simply that you're being represented by your local representative. You're the guy you elected to be, you know, your president, the guy you elected to. That's, you know, your immediate person in the union to represent you for that. So the union has to provide somebody for you. Okay, so anyway, now there are also independent contractors. Independent contractors are usually firms that do specific kinds of work. Let's say that your employer has decided that he needs a bigger parking lot, and he doesn't want his employees to build the parking lot. They're going to be busy doing their regular work. Even if he had some employees, you know, had been laid off, he's not going to call them back to build a parking lot. He typically is going to go out and hire a professional firm to build the parking lot. And of course, the people who work there are just ordinary workers, but they're working for this professional firm. You know, so it's a construction firm, and it typically would have had some experience in building, and has people who know how to build, know about construction, whereas his employees don't know that, so he usually would do that, outsource it to people immediately in the area, companies that work in the area that do that kind of thing. So that's an independent contractors. Many of you, when you buy your house, let's say you become successful, you get a job, you're married, you decide you want to have a home, you find a home, you buy it, but you know, you and your wife decide that the kitchen isn't what you want it to be. You want to update it. You want to make it look better. You want to remove all those old cabinets. You want to remove all those tiles on the floor. You want to put in new appliances, you want to update the kitchen, very typical kind of thing for people to do. Or you want to build a deck on the back, or a patio or something. Anyway, you hire an independent contractor to come in and do that. You interview several people, and then you'll pick one to do it, and you'll sign a contract. The contractor will usually come with his own contract. So, of course, that's going to be a contract that will protect him. You might need to look at it and make sure it protects you. You might want to run it, if you think there's something funny about it, you might definitely want to have a lawyer look at it. And there's all kinds of ins and outs I'm not going to go into here. I used to go into that when I talked about, when I talked to my people who were studying finance, personal finance. Anyway, wrongful discharge doctrine. So if you don't have a contract and you're being fired and you think they're firing you for some wrongful reason, maybe you can make a case for that. So the wrongful discharge doctrine relates to several things. One thing would be actually a contract, but this comes in that some people have in the past have argued that certain statements that are written out and handed to an employee manual, a handbook. So a lot of employers will have a handbook that they give to the employee, and that handbook will have in the past, they've sometimes had statements about what would happen if they were to decide to fire you. And it might say that you have a right, you will be given a hearing or have a right to a hearing. It's not a contract. And usually, typically it says very upfront that it is not a contract. That's there, and that was put in there because there had been some cases years ago. Before I went to law school, there were cases in the 60s and the 70s where people would argue that these things were actually contractual. And there were some states in which they were held to be. There were a lot of states where they were not held to be. And so for employers to be sure that that doesn't happen again, they put in there a statement that these are not a contract. So you don't get the ideal that you can force them to actually do what they're promising to do. They're actually able to amend that and change that anytime they want without notifying you. And so, because it's not contractual. Wrongful discharge for, the inclusion of contracts, those kinds of manuals don't work for that nowadays. I don't think that it's going to work. Employers are not going to allow that to happen. Anyway, public policy. There are certain things that you can't fire a person for. For instance, one thing that all states would recognize, I'm certain, is if you got called up for jury duty, you go to your boss and you say, oh, I've got to go down to courthouse on such and such a day, can't come into work. And your boss says, oh, I need you here. If you go down to work, if you go down there to the jury, I'm going to fire you. You can't do that. And you need to explain to him, I would explain to him gently that, well, if I don't go down there, I believe what happens next is, and this is what happens next, the judge will issue a order, and and I will be held in contempt of court under this order unless I show up. And so if I don't show up, he'll send out some sheriff's deputy who will then escort me down to the courthouse, and I will be before him, and he'll decide what he should do with me. And he can throw me in jail, and if I tell him I'm not going to honor my duty, he'll definitely throw me in jail. And if I tell him that you have told me that I would be fired should I go down and do my jury duty, he will send you a contempt of court, and you'll have to go down and appear before him and explain yourself. So you can't do that. The judge will discipline you for doing that. So that's a matter of public policy. There are other public policies that also come into play. One very common one is, we have it in Indiana here. We have the former one, the previous one in Indiana. We also have this one. Let's say that you happen to be on the job when a fellow employee has been injured while doing his work, and he's injured in a workplace accident, and he's not able to work. Doctor told him not to go into work. He's seriously injured, and he shouldn't be working. And so the employer wants to contest workers' compensation that he's seeking. Why would the employer do that? Well, the employer would do that because employers are charged by the Workers' Compensation Board in Indiana a certain amount of money, and the amount of money they have to pay into the Workers' Comp Fund matches up with pretty much the likelihood that somebody might apply for workers' compensation. So if he has a lot of people filing these claims, at some point they're going to raise his rates, so he might want to contest that, and he might just do that automatically. Well, you could then contest his contest. You could challenge him that, and you probably have to go get a lawyer. And so you go get a lawyer, and then you ask the friends of yours who witnessed what happened to testify on your behalf, so you could establish that it was work-related and that you were working at the time. And your friend does, and then he fires your friend for doing that. That firing of your friend would be against public policy, so it won't stand up. He'll be reinstated, maybe get back pay. Maybe he might want to go back to work for that same employer. Maybe he'll just take the back pay and go work for somebody else, because he might fear that the employer might find other ways of hurting him. Anyway, and so that's public policy. Now, the final way that you can claim a wrongful discharge is to show that there's been some tort committed by the person who's basically employing you. All kinds of torts, any kind of tort theoretically can be made. Most frequent kind of thing would probably be defamation. You were fired because somebody defamed you, and you challenged it, and they could never bring forward a person who could testify credibly that you had committed whatever was causing. I say that your accuser has said that you stole money from the till. Somebody took money from the register. Was it you? He claims that it's you, but he doesn't want to testify. Okay, so the employer can't prove it, and which means that they can't fire you. They can't fire you without proving that you've actually committed that thing. If they fire you on that basis, you've got a wrongful discharge case. So what employers typically do is not tell you that somebody's accused you of defamation. You don't know why you're being fired. They just tell you, we just don't think it's working out. You're just not really for us. We think you'd be better off somewhere else. Whatever. They tell you something to get rid of you. They could tell you that they don't like your yellow tie, that you don't dress very well, anything to get you out of there. You're not working it out with other people. You just don't gel with the group. You're not a team player. Anything, something that's maybe subjective, and they may tell you that, or they might just put an envelope, or like one of my cousins told one of his employees one time when he had to fire him because he had been making threats against women, and he knew the women didn't want to testify, so he didn't want to get into a court contest, and so he didn't want to answer a lot of questions on it. This particular employee, when he called him in, well, he first off, he just sent a pink slip into his envelope, which that's what you get when you're being fired. And when the employee came in with the pink slip, said, "What's this? What am I being fired for?" He says, "You know why you're being fired, and now get yourself out of here, or I'm going to call the police and I'm going to call security and we'll have you thrown out." So he didn't want to tell him why. He had a reason, but he didn't want to make it an issue if he could avoid it, and so he probably would have found some reason to fire him anyway. That's a difficult position for a manager to be in, where he's got employees who he believes, maybe more than one, maybe several, in this case it was several women had told him the same story, and he believed the women and not the guy, and he thought it was credible that the guy might be doing what they said, and he just simply found a way of doing what he thought he should do. If you can allege a tort, that's fine. So defamation, like I say, is a very common kind of thing. So that case, the worker might have wound up arguing that he was being defamed by these women, that he hadn't done any such thing as that they were all liars, right? And yeah, but that would have to go. If that was litigated, if he had a number of women, if he could get them to show up and testify at some point, I think that would have stood up. But for him to say it is secondhand, it's hearsay. You can't introduce that in court. So that's what he wanted to avoid, all troubles, and so that's how he handled it. Now let's talk about another kind of tort. There were these two jewelers. They owned jewelry stores, and they were operating in competition with one another, and one on one corner and another on the other corner, and both of them were not making money. They were both losing money. And so one day they met over lunch and discussed their mutual plight. They said, there's not enough business for two jewelry stores at this corner. So they worked out an agreement where one of them, let's call him Tom, agreed to hire Sam to work for him, and promised Sam that he would employ him, and promised him that he would pay him a bonus at Christmas. And so it's July, and they signed this agreement. And so Sam closes down his jewelry store, maybe transfers the jewels to that, and gets a certain amount of payment from the other guy for the jewels, or he sends it back. A lot of times jewelers work on consignment. He sends back jewels to whoever it was that has those jewels in his stores that he sells, and that's the way jewelry works sometimes. And so he goes to work for Tom, but Tom, after a couple of months, tells him, "Oh, there still isn't enough business here. I can't support you as an employee. I'm going to have to let you go." Now, ordinarily, if somebody's hired you and there isn't enough business, he would have a right to fire you. It would be a good reason. But in this case, there were promises made. And so Sam made the case that Tom had committed fraud, that he hadn't intended to do that. And I don't know. I guess if I were a judge, and I would expect to see the accounting of what the business was actually making before and after, and but the judge in that California case decided that there was fraud and ruled for Sam, and basically Sam then received a certain amount of money for time maybe that he didn't even work, so that would be a tort. There was another case in Michigan which struck me as really odd. I couldn't believe this case when I read it. A man had been working for this county department for 25 years. And for the last few years, I don't know, maybe the last 8-10 years, he had been getting very low performance reviews. That's not true of his earlier work. He had been getting better reviews earlier on, but he was now getting really very bad reviews. By that I mean he was getting average reviews, that is C's, okay? And actually in employment, where they do these kind of reviews, oftentimes a C is considered to be a bad review. And so they decide that, they call him and said, well, your work is not really up to our high standards, and we have standards, you're just not doing it, and we've got to let you go, and because you're just not really doing the job. And he said, well, what do you mean? I'm always getting an average kind of, you're telling me I'm average, and you're telling me I was okay. And now you're telling me I wasn't? And so he sued, and it shows you that a manager needs to sometimes be blunt if he thinks something's not working out. So he sued, and they said that the company and the manager was negligent, okay, and not telling him that he wasn't doing the job. If the manager had told him what he was doing wrong and that he was doing wrong and he needed to shape up, then it would have been a different story, right? He could have maybe improved his work and done satisfactory work. Oh, that was actually what he was getting on his reviews. But anyway, in that Michigan case, he won on account of the tort of negligence, which I was surprised that anybody could win on negligence. But theoretically, any tort will do. Okay. All right. Statutes. we'll talk about anti-discrimination statutes later, and before I get into the statutes, and we're also going to be talking about the whistleblower statutes before we talk about anti-discrimination statutes. Before I do that, let's talk about contracts a little bit. Okay, there must be in assigned writing. Courts are reluctant to accept oral employment contracts. Employers often give employees a handbook. So I already talked about that. I think you understood that. But there's a slide in that that covers it too. Vicarious liability. Okay, now this is what I was talking about. An employee can create liability for the employer if he commits a tort. So if an employee, first thing is, if the employee harms any person and that person sues the employer for damages, that would be on the basis the employee would have committed either a negligence or an intentional wrong, for the suit to arise. Okay, and so we call it vicarious liability. And there are two broad theories under which courts will proceed in these kinds of cases. The older kind of theory is what we call respondeat superior, and this puts strict liability on the employer if the act of the employee was within the scope of employment. The employer precautions, training, instructions, close supervision are irrelevant. They're liable because he's strictly liable for the firing. The employer is strictly liable for the actions of his employee. Your employee harmed this person through his negligence. He was working for you. He was doing some work that was not part of his job, and in that, so there are a lot of cases on that. One involved a bus driver who delivered cookies and loaves of bread to a store, and he got into an argument with the store's manager, and the argument was where his loaves and his cookies were being placed. Now, these stores oftentimes have arrangement with different companies, and sometimes there's preferred shelving. So if you're selling cookies or anything really, you want your products to be right there at chest level where people will grab it and put it in their cart, right? You don't want it to be too high where someone can't reach. You don't want it to be too low where they have to bend down and get it because they don't want to bend down. So they're more likely to buy more stuff if it's in the middle there. So you want to have that. So that would be preferred shelving. Apparently they had some sort of agreement, and when the bus driver came in and was unloading because the bus driver would, oftentimes in these situations, will be loading up the shelf with his product. The bus driver found that somebody else's cookies had been shelved there. And so he called the manager over, and the manager got into an argument with him. They got into an argument, and the bus driver, or the truck driver, slugs the manager. And so this is what the employee shouldn't be doing, right? Now this is a tort. This is a wrongful thing. This is a battery, and the manager sues the truck company, the bakery, okay, that made the loaves and made the cookies, for the actions of its driver, and they won. That's the kind of thing. It's just simply, well, he did this thing, you're liable, okay, and that's called respondeat superior. Let the super person, let the owner who he's working for, let the master pay for that. So it goes all way back to Roman times, where the Romans had the same rule. If you had slaves or servants, you were responsible for any harm that they did to anybody, and you were just going to have to pay if they did something. And of course, you would severely punish your servant for doing that kind of thing, which you could do. Now the other theory is called direct liability. Okay, and so basically, in the former saying, oftentimes you'll find in the opinion they'll talk about employer precautions such as training, instructions, close supervision, that is closely monitoring the employee. And I said, you know, it really was not really under respondeat superior, that none of that made any difference. Under just direct liability, it's going to make a difference. So liability for negligent hiring, supervision, or retention. So these are the things, these precautions are basically required to be done on a good level. So, you know, you hired somebody for daycare, and he turns out to be a child abuser, and he has a record. You know, he's you know, classified as a sexual pervert under the law, and you know, you should have known that. He's got a record. You could have looked it all up. You're supposed to, you know, you should have checked out his bona fides, I guess, before you did that. So it requires management to be negligent in precautions. So that's one thing you could claim that they were being negligent. Or you've got, let's say that you're an oil company and you got these big tankers hauling oil all around the world. Sometimes there have been these accidents involved with that. And we talked about the Exxon Valdez. What was really involved in that was that the pilot, who was supposed to be piloting the ship at that time, got drunk and was in his bunk on the ship, sleeping it off, while, you know, people who really weren't pilots were piloting the ships, and they ran the ship aground onto shoals that were that could not be seen below the ground, and you know, you had to follow certain channels, and a pilot should know where those are, but these were not pilots and they didn't know, and they the oil went all over, causing billions of damages to the local economy and ruining a lot of wildlife. And it was an ecological disaster, environmental disaster. So that would be a case where, you know, they're liable, directly liable for it. Again, it's strict liability. I mean, you know, once you show that they have been negligent in hiring and keeping this person on, with, you know, the oil company knew that he was a drunk, he'd been in that shape before, he'd been doing this, and they knew that, and they kept him. So there's a danger. You might say, well, this guy is reformed. You have the same thing in terms of maybe a church keeping ministers or priests on who have, you know, let's say they have, you know, done things with little children they shouldn't be doing, and is the church going to be held liable if they knew that these people were doing it, but thought that they had reformed? Yes, they will. So you can't, if you're the Catholic Church or the Methodist Church, you can't like send these priests to be re-educated, so to speak, to become reformed, and they come to you and say, okay, I won't do that again. But then it happens again, you're going to be liable if it happens again. So it's sort of like having a dog. You can keep your dog, but if you keep your dog, if you bit somebody, you're going to be liable after that. So it becomes strict liability, doesn't it? So that's the two theories. Okay. What we see in these cases is a movement that employers, you know, that has happened over the last couple hundred years. And the common law courts have basically moved the liability here from what it was. You know, there was actually more protection under the old common law rule than there was under the newer rule. Employers benefit from the work their employees do. They select, train, and supervise those employees. Individual employees rarely have the financial resources to pay for the injuries that they cause. In contrast, employers have deep pockets, right? And they can easily obtain commercial liability insurance. And if they don't want to self-insure, that's what they should do. These losses, moreover, the unwitting victim or of employee torts have few realistic opportunities to prevent those losses or those injuries. This explains why the courts would hold well, I meant to give you an example called the mattress factory. I think I'm going to do that. Mattress factory case. I thought I had that here. Anyway, what that case involves is there was this mattress salesperson who had sold some lady a mattress, and that was delivered to her home, and she wouldn't sign the receipt when she received it. Now, you know, the delivery driver was supposed to get her to sign the receipt, but she refused, and he brought it in. She wouldn't let him in again for the mattress. He said, well, I have to take it back, and she wouldn't let him. So the salesman, of course, he's making a commission on the sale of that mattress, and so he wants to make sure that this sale is finalized and that she pays for it. So he goes out, he gets the receipt from the delivery man. Normally he doesn't deal with the receipt whatsoever. He tells her, okay, you can buy it, oh, go over there and they'll fill you. And usually they have a separate person who handles the finance and handles the contract. And so he doesn't have any information about her. So he gets from the delivery driver the receipt which has her address on it, which he's not supposed to have. And he goes out to get her to sign the receipt. She, I don't know, I guess initially resists, and then he threatens her, and he forces entry, but he goes further and he actually rapes her. Okay, and you know, so they fire him, and he tries to claim that it's, you know, they shouldn't be firing him. You know, basically, he hasn't got a leg to stand on, right? You know, and she's basically, you know, he's going to be fired, and they're going to have to pay for, you know, what he did. And so whatever the court decides it's worth, in these kind of cases, is oftentimes you're talking about a subjective judgment of the court. Could be a lot of money. And, you know, theoretically they can collect that money from him if they pay it out. They're going to have to pay, though, and they probably won't be able to pay it. Why is he working as a salesman for some mattress company? You know, so he probably didn't have any money. And so the norm it's called the cost internalization norm, is that the firm will absorb these costs. And that's what the theory is, that this is why we have these rules. Now you might say it doesn't seem fair that they have to pay for his rape. Well, on the other hand, he was only able to obtain her address because he worked there and was able to get the receipt. And, you know, they shouldn't, you know, the delivery guy should not have given him the receipt. He should never have known even where her address was. If he had known it accidentally, that might have been a different kind of case. But even so, he did gain access to her with that receipt, and therefore they're being held liable for that. So this is to internalize, this is an internal norm. The cost becomes internalized to the cost of doing business or a store. So that was, the case was Lyons versus Carey. Yeah, and it's also, I was looking for it here, but it's all in there, and you'll find that I've pretty well accurately reported what it was. Anyway, so that's cost internalization norm. Okay. Courts overvalue the precaution of discharge firing or refusing to hire risky employees, and they ignore the danger of employee churning. I don't know. I'm probably not going to ask a question on that. That's a theory that I don't think really has much potency here. You know, I just don't think that I can see that us using that. Let me go to next slide. Wrongful discharge. Judicial, we already talked about it. Judicial doctrine used by courts to declare certain firings to be violations of important public policy or wrongful tort or public policy may be invoked even absent a statute to protect an employee from retaliation. So sometimes you have statutes that are meant to protect an employee from retaliation, like, for instance, whistleblowing statutes, which we're going to talk about also. Whistleblowing statutes, basically, if you report to somebody outside of your employer, let's say a newspaper, you might be protected by a whistleblower statute. Then again, you might not. These things vary from state to state, and some states have strong whistleblower statutes, others don't. And you see some federal laws also have it. So Sarbanes-Oxley has one for people who want to report financial wrongdoings to the federal government. And there's a provision in there, you know, you can claim protection for whistleblowing under that provision of the Sarbanes-Oxley Act. But my understanding is nobody's been successful in getting that recognized as protecting them, the last I looked, which was some time ago. But you would have thought somebody, after 2 or 3 years, you would have thought somebody would have been able to do it, but I guess not. Anyway, and so statutes. Like I said, we're going to be talking about whistleblower statutes, equal protection or anti-discrimination statutes, whatever you want to call it. I like to call it equal protection statutes, but also anti-discrimination. You know, it's just the same thing. Now these statutes, both the whistleblower statutes and the equal protection or anti-discrimination statutes, they can be either state laws or they can be federal laws. Of course, nowadays there is you know, equal protection under the federal law, but there are also, most states also have parallel to our federal equal protection laws, their own equal protection laws. And you may have to file with your state thing. And so the state might have some initial jurisdiction, but if you don't get satisfaction, you don't like the ruling of the state thing, or you can't come to a conclusion with them, after waiting a 6-month period, you can then apply and with the federal government, apply with the, can you sue them under equal protection in a court of law? Not until you first go through the Equal Employment Opportunity Commission. That's the federal agency. If you've gone through them and you know are not satisfied with their decision, you can appeal that to the federal courts. So it becomes a matter of appeal. So this, why is this? That's because there was some concern when they first came out with the Equal Protection Act that the courts would be inundated with lawsuits. And so they were going to just have an agency do that instead of hiring a bunch of new judges, which would be a very expensive kind of thing to do. You also would need more courthouses, you know. Whereas an administrative law judge, nowadays they call them administrative law judges. Back then they were not called that. They were called, oh, I don't know. They were called agents of some sort. So they were agents that worked, and you would appear before them. Hearing commissioners, I think, are, you know, but they've been elevated in that way. So anyway, so equal protection, these statutes that further public policies, for example, voting protection, jury duty, and military service protection, are very frequently, there are statutes in the states for that. So, okay, let's at least do something with whistleblower protection statute here. Statutes on discrimination. So we'll go over the traditional statutes of federal law that cover it. The Equal Pay Act of 1963, the Equal Employment Opportunity Act of 1964, the Age Discrimination in Employment Act of 1967, and the Americans with Disabilities Act of 1990. And then there are, like I said, there are these state laws that either predate or follow the federal laws. These might involve the same or additional protections beyond the federal laws. So New York would have one where they go beyond the federal law, provide you more protection from discrimination. Many states and localities have changed their laws, and recently a lot of those changes were in regard to LGBTQ. So, you know, it might be a city or a state that has a provision protecting people from that. So these would be sometimes state laws. But recently, like in 2020, the Supreme Court has ruled that people are protected from discrimination for being LGBTQ. And that was by a decision, and we'll go over that decision when we get there along. So anyway, the Equal Pay Act is interesting. Now, the Equal Employment Opportunity Act, that's the one that's going to protect you under LGBTQ or whatever. I get it wrong. Anyway, the Equal Employment, that was part of the Civil Rights Act of 1964. Before the Civil Rights Act of 1964 was passed, the women got pushed through Congress an Equal Pay Act, basically saying that, you know, if they were doing the same work, they should be paid the same amount of money. So there's this Equal Pay Act in 1963. And the Age Discrimination in Employment Act also comes in later. It was not part of the Equal Employment Opportunity Act, not part of the Civil Rights Act of 1964. It was meant to take care of employment and age discrimination. The Americans with Disability Act came even later. So, the age discrimination came 3 years after the Equal Employment Opportunity Act, but Americans with Disability Act didn't come along until 1990. And like I said, there are state laws that actually provide for it. Now, the Equal Pay Act is kind of interesting. I want to get through as much as I can of this. Let me get my mouse here. It's run off on me. Let's see, the Equal Pay Act. I want to make sure I don't miss anything. Prohibits gender, salary, and wage discrimination if the job content is the same. So it has to be the same job. It cannot be a job of comparable worth. Does not require equal pay if the jobs are considered to be of comparable worth. Does prohibit pay differences based on. Does not prohibit pay differences based on seniority, merit. So for instance, if you're both making parts and you get paid by the piece and you produce more parts, you'll get paid by the piece. That's fine. That's not discrimination if some man got paid more than you. Most of those situations, the women do produce more. I'm going to tell you that. I've been in factories, worked in factories, and the managers preferred giving this work to women because women would produce more and they had a good reason to do it. So, or any other factor than gender. Okay, now comparable worth. What is comparable worth? Comparable worth is basically, you bring in a psychiatrist, he looks at two jobs and he says that these two jobs require the same level of skill and ability, and the same amount of effort is made by the people who perform this work, and therefore they should be paid the same, and they contribute the same in some ways to the success of the organization. So they're of equal worth according to this psychologist rather, who studies these things and is an expert on it. And he says that they should get paid the same. And so the classic case would involve usually a person who directed trucks on their destination. So he would be telling the trucks how to get where they're going. So they used to hire these people when they had delivery service. A company was maybe delivering its product to stores all over the state or all over the country for that matter. And these trucks were going out, and sometimes they'd get lost or they'd run into a roadblock, and they'd call in for advice on how to get to the store. And so this person sitting at this desk would then, being basically an expert on these kinds of things, would direct them how to get there. And he had to know how to work and operate a radio, and nowadays, of course, maybe even some other kinds of electronic equipment. These were dispatchers, okay? Dispatchers used to do this. Now I don't know if they need dispatchers to do this anymore. Most truck drivers might be given instead a GPS, right? So maybe it's a job but this was a classic kind of case. So that guy was compared to an executive secretary. The executive secretary maintains the boss's schedule and tells the boss where he has to be and how to get there. And so, the psychiatrists have come in and looked at these jobs, and they have said, and this is actual case, they said, well, these jobs are of comparable worth, but the man who is typically being hired as a dispatcher, a former truck driver, those truck drivers generally were back then pretty much mostly males, very few, you couldn't, you have to look long and hard to find a female truck driver, and so it's typically going to be a male who would become a dispatcher. Whereas secretaries would typically been women since they began taking those jobs. They prefer being secretaries, and men gradually preferred having women for secretaries rather than men. And anyway, so the women would be paid less, and that was one of the reasons that men preferred them and why they wound up going into those jobs, because they would work for less. But the dispatcher, for male camaraderie, would probably need to be a male in that sense, because the other truck drivers might not respect a female in that job and wouldn't accept maybe her doing it. Although it was possible, because my sister, when she in the 60s, was doing the dispatcher job for a small trucking company, and the truck drivers were fine. They didn't hesitate. She could read a map and she could tell them how they can get to their destination, and so she did it. And I know she could do it well. So that's contrary to the ideal that women can't read maps. My sister could. Anyway, Title VII prohibits discrimination based on race, color, ethnic origin, religion, and sex. So I'm going to end it with that, and we'll be talking about this statute when we come back on Friday. I hope to have gotten further than this, but that's okay if this is what we were started, but we'll definitely need to go through this. And so it's got actually categories. In order to claim discrimination, you've got to claim one of the categories. Under this statute, you have to claim one of those. And just the same way as you have to show that you are of age to be discriminated against on account of age. You have to be over the age of 40. Okay, you can't be discriminated if you were 39. Or, disability. You're going to have to actually show you have a disability. And nearsightedness, unfortunately, is not a disability because you can correct it easily. It doesn't require much. However, if you have a bum leg and have to have a wheelchair or a crutch to get around, that would be a disability. But certain things will be defined, will fit the definition, and we'll see what those definitions are on that one when we come back. And we'll do the rest of the statutes, and some of them, that are discrimination statutes, and we'll do the rest. I don't think we've done whistleblower yet, although I did mention it. I'll have to decide whether what I told you was enough. But there's a lot more in these things, so definitely take a look. And I'm going to give you all of them on this on Wednesday when this goes up. The PowerPoints will be for all of the things that we're going to be covering, except maybe not labor. I think I got that on a separate PowerPoint. But a lot that we haven't talked about today is going to be on that too. So you might want to look at this, but you still need to come through the thing because there's certain things I'm going to tell you need to know that are not necessarily on there, because I think this is an important kind of thing. So thank you very much.